I wanted to certainly stress today in terms of what the Michigan case law says in regards to meretricious relationships. Of course, its basis is because back in 1957, the state abolished common law marriages. So in order for a party to be to prevail in a complaint against their prior boyfriend, girlfriend, whatever label, they have to show independent additional consideration, whether that be expressed or implied, in order to do so. And it makes sense. The law does not allow for scorned lovers who didn't take the opportunity to get married to come and clog up the court systems with something exactly like what Mr. Pliska has filed before the court. And you can't use quantum merit arguments or unjust enrichment arguments either, which also makes sense, because you have to be able to show that at the time the alleged work that Mr. Pliska is alleging he needs to be paid for, at the time he was doing it, he expected to be paid. And at the time he was doing the work and expecting to be paid, my client, Ms. Latier, knew of this independent agreement and was expecting to pay him. And that there's no facts. This record will never develop in a way to show that that was ever the case. As we went through and noted in the affidavit that Ms. Latier signed and we attached to our brief, I mean, we're going through all these thieves of metal roofing, windows and doors, insulation, electrical wiring, drywall, plumbing. Those are not thieves, as Mr. Pliska wrote. Those were materials that were bought solely by Ms. Latier and put into her home. And again, then he gets into what apparently would amount to contracts that were breached by Ms. Latier, but there's nothing that will show that that was ever the case. And now, since we filed my motion back in the beginning of January, and Mr. Pliska hired Mr. Ingleson, and they responded, they didn't respond with any of these potential arguments or agreements that would help their position, because again, that just goes to show that there are none, and if this case is allowed to proceed, none will be